Yes, Mr. Copple.
Your Lordships have some pieces of paper in front of you. Can I explain what they are? First of all, Little and Friends, I think, have provided an extract from the current edition of Clark and Ginzel in relation to procuring a breach of contract. I think, possibly.
I've got an extract from Rule 44.2.
That's from us.
Under ground 7.
That's the paragraph to which I took the court, hearing that the court no longer has access to the current edition of the White Book.
Yeah.
It's the least I could do. And then secondly, from me, your Lordships have a draft ground 7
Yes.
of appeal. I don't have the application notice, but I can certainly sort that out.
Yes.
And it's a single sentence.
You say wrongly failed to deal with issues A, B, D, and E. Yeah.
So, yes, there are two elements to it. He failed to deal with those issues, and the explanation given for him for dealing with those doesn't bear analysis either. So that's 1 and 2. I think, my Lord, that brings me to the end of my submissions, unless your Lordship wants to hear me on the, what is it, actually the cross appeal from...
Well, there's also the matter of your application for permission to serve an appellant's notice out of time with regard to the 31st July order.
Why are you not?
Yes.
Why are you not pursuing that?
No, I should have included that in there. I am pursuing that because that relates to my amended ground 6, for which I was out of time.
Yes.
I do that, and I'll have to amend that needs to be in the application notice rather than as a ground of appeal.
Yeah, well, I mean, the paperwork can be sorted out afterwards. I mean, strictly speaking, as we said earlier, you needed a separate appellant's notice, and it would have been out of time even if you'd filed it when you filed your application notice, let alone now. But it still leaves 2 questions outstanding, which is, 3, I think. Firstly, whether you should have the extension of time. Secondly, whether you should have permission to appeal. And thirdly, which bears upon questions 1 and 2, what's the point? I mean, I see the force of the argument you wish to make, which is the judge should never have done this for multiple reasons, in particular because the application was made by the second defendant who had no authority to make it, and there was no application by the first defendant. So I understand that, but what's the point? Why is it not wholly academic?
It's not wholly academic in this sense, my Lord. It goes to the general approach, if I can put it that way, of the judge to the determination of this issue. The changing of a sealed order months after the order was sealed, and indeed after the appeal had been lodged with this court, and to do so not on any analysis as a slip, but really going to the substance of the judgment.
But that goes to the merits of your argument, and at the moment, I don't have much problem with that, obviously, without necessarily having heard what the other side have had to say about it. But the question I'm asking you is why is the issue not academic? Because what the judge did was to alter the judgment sum as against the first defendant only. It's academic as against the first defendant for a number of reasons. First of all, the liquidators accepted your proof without the benefit of a judgment. Secondly, the liquidation is closed. What possible good could it do you, even if you were to reinstate the original order?
My Lord, I totally accept all of that. I completely accept it. I mean, it is as against D1 and D1 only. The only...
Well, look, Mr. Copple, in order to get this ground off the ground, you will need to address the Denton test.
I know.
And you haven't yet.
No.
And in the light of my Lord Justice Arnold's comments, perhaps you'd like to consider your position overnight. And if you wish to remake your application or reopen your application, you can do that tomorrow morning.
That's what a very fair offer which is being granted to me, and I'll certainly take it up with those instructing me.
And
I see the force in what's being said. I totally understand it, but your lordship will also understand how it really did stick in the throat of my clients.
Yes, well, maybe. Now, as far as your ground 7 is concerned, again, we're not going to rule on that now because your opponents have only just seen it. Anyway, that's the ground you want to advance. The point was flagged up, of course, in the third defendant skeleton argument. So, as though it's a new point sprung on you. And again, you're going to have to persuade us that, notwithstanding that it's an amendment made very late, nevertheless would be right to allow you to do it. But as I say, we're not going to rule on that this afternoon because your opponents need some time to consider what their positions are.
That does then leave the issue of D2's appeal. I had wondered whether your lordships want to hear me on that first before my learned friend, but in light of, in particular, the fourth ground, for my own part, I would like to see that developed by
Yes.
D2, as it's quite a bold, if not courageous submission that's being made, and I do want to see how
Yes,
it
by all means.
pans out.
Yeah, fine.
Grateful.
Right. Mr. Ingham.
Thank you, my lords. There's two matters that I want to address you on. The first one is this issue of the unagreed bundle in my client's application.
Yeah.
The second is about the order of events, because I've had the opportunity to speak to my learned friend, Mr. Budworth, about the order in which your lordships may want to hear us, given that it's my learned friend's client primarily who has submissions to make in relation to the submissions you've heard from leading counsel this morning. And we had wondered, or I should say I had wondered, whether it would be beneficial for my learned friend to address you this afternoon, because that is centrally on these issues of inducement and grounds 1 and 2. And then for me to be able to address you tomorrow morning with my appeal, which of course raises different points.
Well, whatever's convenient for both of you and whatever's the most efficient use of time.
Yes, my lord.
As far as your unagreed bundle is concerned, I don't know anything about it. I have no idea what's in it. What it's going to add to the sum of human knowledge.
I will address you on it now then, my lordship, and I propose to keep it under 15 minutes. As I heard directly this morning that you did not have a copy,
No.
I asked for copies to be printed then and there. I now have them and they have been brought up. Now, I should warn you before you see them, they are quite long, and I hope to explain why that is. But if you are minded to look, my client made an application for the unagreed bundle to be relied upon on the 13th of March, and delivered the bundle on the 15th of March, having received notice that the application notice had been sealed on the 14th. So it is properly made and properly before the court. I think before I address you on why you should grant permission, it's probably, if your lordships are minded to, sensible for them to be passed up to you.
Or just, you're right, but just tell
Well,
us what's in them.
Yes, my lord. So the
Why the contents are important.
So there's a number of areas that are touched upon, my lord. The first one is it has the costs judgment in that you were asking for this
Right,
morning. So
we've
that
got-
was the first reason why it was relevant,
Got that
which
now.
there was a refusal to agree its inclusion in the bundles. The second is there are first instance documents that were all in the trial bundle relating primarily to the evidence that was before the court on my client's defence of the claim against him. The reason that the content of the documents doesn't directly go to when I say my grounds of appeal, of course I mean those of my client.
Yeah.
It doesn't go directly to the arguments I'm making in my grounds of appeal. What they do instead is they relate to documents that were before the court on first instance, and to which reference need to be made if the question is posed as to what difference there would have been if, for example, the procedural irregularities that we allege had not been present, all the sorts of things that my client could have said had he had adequate notice or had matters been adequately pleaded. So the basis on which we ask your lordships to look on them, firstly, is because they were before the first instance court, and secondly, because necessarily in our submission, and particularly with respect to the new ground 7, potentially, it may be necessary to look at some of the first instance material in deducing the value of arguments that we make. There aren't any specific opposition, there isn't any specific opposition taken to individual documents. I do note that there are 78 documents in this bundle.
Asking this court to look at 78 documents.
No, my lord. I think I would not be able to invite you at this stage to sit and consider the. I'm sorry, my lord.
What's the point of putting them in a bundle then?
My lord, it's unfortunate because they were originally sought to be put in my client from the outset. And of course the parties had negotiations about what was going to go into the bundle, and that then ended up.
I mean, neither party is attacking the judge's findings of fact insofar as he made them. There are complaints about findings that weren't made and allegedly should have been made. But in those circumstances, why do we need to look into the factual material?
So I'll try and answer that question in two ways. One is in a general sense and one is in a more specific sense. In the more general sense, when we are making our arguments that my client didn't have, for example, an adequate opportunity to have notice of the arguments that were being made against him, or when we say that there was procedural irregularity because the claim wasn't properly pleaded, my client says that he would like to be able to have me make submissions to you about the sorts of points that could have been taken had he had that notice. Now, that is not...
Is this trailed in your skeleton argument? The points that he could have made?
My lord, no, it isn't. And the basis on which the basis on which I'm instructed is essentially that my client wants to be able to refer to material that was before the first instance tribunal in circumstances where the question may be asked, what difference does it make or what difference would it have made? Now, I appreciate that that sounds a lot like I'm saying I want to introduce new arguments and new material, and I'm not proposing to do that.
The purpose of the skeleton argument is to set out the submissions that you wish to make to this court. I mean, it's not just a headline.
Yes, my lord, I quite agree, and the skeleton argument sets out the arguments that I want to make in relation to the grounds of appeal for which I have permission. I recognise also as well that there was not permission granted for ground 1, which did involve an application to produce new material and new evidence to make arguments that are similar. So it is right that I sort of signpost that while I'm making these submissions. Having said that, though, I would suggest that the balance should be in favour of allowing, well, dealing with it in two ways, either allowing reference to be made to this bundle, or if the court is not minded to allow reference to it in its totality, then at least being able to perhaps consider reference to individual documents later on if it becomes apparent that it's appropriate. Because it may be, for example, that there are the contractual documents in question in this bundle. There are transcripts not just for the cost judgment, but also from the earlier proceedings, including the proceedings at injunctive stage. There's also other documents which relate to the interim applications that were made. And it may really be that those are of use at the particular time. So if your lordships are not minded to allow the entry of the bundle, what I would instead propose is that if it becomes necessary and relevant, I can address you on a specific document at the time. And of course, then that can be taken in the context. Individual documents if it's necessary.
Yes, all right, Mr. Ingham. We'll listen to you on individual documents if and when it becomes necessary, but
I'm grateful.
not minded to let the whole come to you.
And I'm grateful, my lords. And I think I answered your lordship's question when you asked about the ordering of events.
Yes.
And yes, we had agreed that
All
Right,
right,
if I would address you
so we're
first.
going to hear from Mr. Budworth
I'm
first.
grateful. Thank you.
Yes, Mr. Budworth.
My lords, in the blue ring binder which I've brought, there are some extracts from the up-to-date edition of Clark and Linsell because that observation has been correctly made. I've also brought,
Sorry, reference has been made to a blue ring binder that we don't yet have.
it's about to be handed up.
Very good.
There's an important additional authority in there, Kawasaki against Campbell, which is about
Yeah.
causative element. The appeal's got to have regard to that based on the argument that we've heard this morning. So there's a copy of that authority.
Thank you. All right, what's the difference in Clark and Linsell?
We haven't studied it to be able to signpost where the departures are between the 23rd edition and the 24th, but at least we've got the up-to-date
Yes.
edition. If we can find it. There's a further authority, given that the respondent's notice brings back into play the issue of justification. If there had been an inducement, was the justification? There's an authority explaining why that's a proper matter for a respondent's notice, not a cross appeal in case we get into that. But I'll start with ground one, which is the question of inducement. At its core, the question is whether facilitation is enough. So the judge said there was merely a placing of orders by D3, and he said without more that was not enough. The observation of my Lord Phillips so far on the basis of it takes two to tango is that if there's an order, but for that order there can't have been a breach by Genee World, we have to test whether that's sufficient to attract tortious liability. Nothing may ultimately turn on this, but it should not escape the reckoning that the way ground one is expressed is already actually a subtle shift from the way in which Northamber put its case to the trial judge. So ground one, page 36 of the core bundle. Is put in the terms of facilitation of a breach by enticing the third party to supply. And it may be said that I'm dancing on the head of a pin because at the end of the day, IES placed orders and Genee World fulfilled those orders. But I say it is a subtle shift and it's an identifiable shift because if one looks at the judgment, beginning at paragraph 215. The learned judge could only deal with the case as it was being advanced to him, and he does so extremely thoroughly. Firstly, to start with the pleading. Statement of case at paragraph 215, which is a faithful rehearsal of what the statement of case says. It's quite odd structure because in line 3 of this paragraph, Northamber had pleaded that IES knew that and intended that by placing orders, it would persuade and did persuade. Well, those two things are not the same for a start-off. And thereby breaching
what are not the same?
would persuade and did persuade.
No.
So
What is being said is that IES intended to persuade and did in fact persuade.
yes, Yes.
Yeah.
So Northamber appears to be taking on an obligation of finding some active persuasion at the beginning of the case, that is.
But it says by placing orders.
Yes, it's mixed. It's mixed. So now on appeal, Northamber says, well, the mere placing of orders was and is sufficient, and the judge was wrong to hold otherwise. But before we leave the statements of case, there's a purposive element that Northamber brought in, which is that the effect of this is that there would be a breach of the exclusivity contract with the claimant, the aim of which was to undercut the claimant or its resellers. So the allegation was that there was a combination effectively by Genee World and IES because they were acting in concert so as to undercut Northamber, which is very different to the very narrow basis upon which the appeal is now framed. Be that as it may on 215 in respect of the statement of case, the judge at 216 next turns to the evidence in chief. And here there is a limitation through Mr. Henry that his belief is that the mere placing of orders would persuade Genee to supply. Then at 217, the judge addresses how that was actually explored in the live evidence.
Sorry, which one? Which paragraph?
217. So we dealt with the statement of case, we dealt with the evidence in chief, and then the judge introduces how this was examined by the judge with Mr. Henry in a question from the bench to Mr. Henry. And Mr. Henry's reply was, well, IES ordering would make Genee supply. Well, why? And Mr. Henry says, well, I don't know why Genee is breached. And then at the end of that paragraph, after further pressing from myself, Mr. Henry said that the mechanism by which IES had persuaded was simply the placing of the orders. Just that.
Yes.
Then
so,
at 218.
so the final allegation is that IES persuaded Genee to supply products by placing orders with Genee, knowing that Genee would breach the exclusivity agreement if it fulfilled them. So
Yes.
that's the way the allegation ends up.
Yes. Then there's the issue at 218, which we saw earlier, which is, well, have IES induced a breach in respect of Genee World supplies to anybody else, to a third party? Northamber's
That's
counsel.
no longer pursued.
Yes, there was a surprising answer given, but that's no longer pursued. 219 is the judge's conclusion on the issue for ground one, which is the placing of orders without more, Mr. Henry having accepted that there is no more, is insufficient. Then for three reasons. Firstly, a timing issue upon which the judge concludes that Northamber was simply factually incorrect. But then at B, Genee was already breaching the exclusivity agreement. So the idea that suddenly when IES place orders, that is causative, the judge rejects that as not making any sense. And then C, a rehearsal of the fact that the case of Northamber is that merely placing orders. So 220, that case fails because the judge does not accept that that's sufficient. We say the balance of authority is against the appellant, and the primary decision upon which we rely is a decision of this court in Kawasaki and Kemble, which your lordships now have in the blue ring binder. Forgive me, before actually getting to that decision, in the same blue ring binder, but the second tab, there should be an extract from Clark and Linsell beginning chapter 23-39.
Yes.
The editors firstly note in the first line of 23-39 that one of the main effects of the House of Lords decision was to reduce the range of acts which could amount to tortious conduct. Then there's the differential between actually persuading being the core instance of the Lumley and Guy tort, that's 23-40, and then an explanation of how the indirect means now fall out of that tort and fall under the causing loss by unlawful means tort instead. And then at 23-42, this is really at the heart of it. The fact that the contractor was willing to be induced is no defence if inducement has taken place. However, if he's already decided not to perform, which of course is exactly what the judge was saying in the judgment at para 218, then the inducement should not give rise to liability, except in circumstances where a party could not break the contract without someone such as the defendant providing assistance. The essence of procurement is causative participation, and that footnote references Kawasaki. So if one then turns to that behind the next book one tab, the examination of the issue in this authority arises from a merger of Japanese-based companies dealing with container liners. The effect of the merger is to knock out a UK-based subsidiary, which has damaging effects for the claimant, James Kemble Limited, and has that arrangement therefore had the effect of inducing or procuring a breach of contract. That's the basic backdrop. In the holding on page 979 of the All England report, it states the requirement that there has to be some conduct amounting to persuasion, encouragement or assistance, and moreover that the participation by the alleged tortfeasor has to have a sufficient causal connection in order to attract accessory liability. That is examined in more detail, beginning at paragraph 23 on page 987 of the report. Firstly and principally at paragraph 25, by reference to Lord Hoffman and paragraph 36 of OBG, which the court saw this morning. Which is a clear adoption by Lord Hoffman of the concept, but on observations that have been made this morning, possibly in connection with a case which did not directly touch upon this issue. So leaving open the question as to whether that active element is on a sound footing or not. But certainly it is at the heart of the decision and the ratio in Kawasaki. So if one moves to paragraphs 32 and 33 on page 989, this court in Kawasaki prefer the conclusion that the essence of tortious conduct is that there's got to have the conduct of the alleged tortfeasor has got to actually operate on the will of the party that breaks the contract. And if the alleged tortfeasor's conduct is not actually capable of influencing the contract breaker's choice, then it hasn't amounted to an inducement.
Forgive me, where are you reading from now?
Forgive me, paragraph 33.
So one of the features that strikes me is that in a number of the inducement cases, you're not looking at a situation where the inducement is by entering into a contract with the party under restriction. And I'm sure that makes a big difference, because when you are contracting with the party who shouldn't be contracting with you, you're affecting a very fundamental change in his position, which causes him to breach his obligation.
But if one takes as the essence of any tortious conduct duty, breach, causation and loss, if the contract breaker is minded to breach the exclusivity in any event and on the judge's findings of fact has already been doing so, and I appreciate this is where inducement and causation cross over, but the reason for the causative element makes sense, because the alleged accessory tortfeasor can't have caused any loss if in fact the contract breaking was going to happen in any event.
I think where that falls down is this. The obligation of the contract party under an obligation is not to supply to anyone other than the client.
Yes.
Every time he supplies someone other than the claimant, he's breaching the contract. But the fact that he has supplied a number of other people breaching the contract doesn't mean that supplying to the alleged inducer isn't also a breach of the contract. So it is a fresh, new breach, which can only occur if the counterparty agrees to do so.
Yes.
If he doesn't agree to do so, it can't happen.
Yes.
That particular breach can't happen.
Yes.
That's why contracting with somebody when you know and intend that will put them in breach of their exclusivity agreement induces a breach of contract and causes
Yes, I mean, that's the fine distinction. Is facilitation enough on the basis that
nothing more. What more can there be?
whatever the motivation of the contract breaker, he has to have a counterparty to
But it's not a question of facilitation, as you rightly say. It's a question of causative participation. Causative. And Lord Justice Popplewell comes back to this at 42, when he deals with the question of inconsistent dealings. It's not detached from the principle. They're an example of conduct which may be capable of fulfilling those criteria because they may constitute a form of persuasion, encouragement or resistance. Then he quotes from Lord Hodge. Between D and E, Lord Hodge says, the tort is not confined to circumstances where A has to persuade B to break its contract, but can be committed where A has dealings with B which A knows are inconsistent with the contract between B and C. In either event, A induces or assists B to do something which involves B breaking his contract with C. So inconsistent dealings are capable of having the necessary causative potency, if I can use that expression. And the complaint made here is that the judge simply ruled that out. He said just placing orders is not enough. Well, yes and no, it all depends. And to take a hypothetical example where a distributor, exclusive distributor, is making a profit of X on each item distributed, and somebody comes along and says, I'll pay you enough to give you a profit of 2X. Well, that's going to be persuasive, isn't it, in inducing the exclusive distributor to break his contract. So placing an order may or may not be persuasive, may or may not result in the breach of contract. So simply to say, as a judge did, well, placing an order can't be enough, isn't right, is it?
Well, my Lord Phillips is stressing the word participation.
Yes.
You cannot have the contract without the counterparty participating. Participation is not automatically causative participation. And so we therefore have to examine what causative participation is. The judge here was
Sorry to interrupt you when you're in mid-flow, but just going back to what you were saying a moment ago, surely the point my Lord Justice Phillips was making is that we're concerned here not just with inconsistent contracts, but we're also concerned with exclusivity. And do you say that the but-for test of causation is not satisfied? If so, why?
no, my Lord Justice Phillips is correct to say that the contract, they've got to have somebody to sell to.
Exactly.
Otherwise the contract can't happen. And so IES, as the ordering party of the stock, is participating. The judge was very much focused on the element of causative participation, on the question of, well, can it really be said so as to make D3 an independent tortfeasor that anything that D3 has done has actually operated on the will of Genee World or induced Genee World's conduct in any real sense? That's clearly what the judge is focused on, and come to the conclusion that Genee World's mind has not been operated on or affected by anything that IES has done, which is simply place orders and leave it to Genee World as to whether those orders would or would not be fulfilled.
Sure, I get that point, but what's the answer to the question I asked you? Do you accept the but-for test of causation is satisfied?
Yes.
Yeah.
The contract can't result otherwise. My Lord Phillips made that clear very early in the argument. That
Right. So it follows, I think, therefore, that you must be arguing for some different test of causation, which is higher than the but-for test. So what is the test of causation that you're arguing for?
Well, aren't I one step removed from getting to it as a pure causation question, which is to say, well, let's firstly analyse and figure out what's necessary for there to be independent liability as a tortfeasor under this economic tort. And that is a question about what ingredients are necessary to make somebody independently liable as a tortfeasor. And the law would appear to be in line with the judge, which is that you need something more than merely placing the order, because you need something which can be properly said to represent inducement, i.e. operation on the mind of the contract breaker. Otherwise,
Right.
the order is simply indistinguishable, whether you're on the supplying side or the receiving side. You've just got the order. Placing the order requires Genee World to make a decision.
Okay, so I think you're arguing that causation is not enough.
Yes.
So what more is required beyond causation? Because I thought your starting point for this argument was you were saying there had to be causation and there wasn't causation. But where we've now got to is you accept that there is causation on the but-for test, but you say causation is not enough. So what more is required?
Well, it's not independent causation by the tortfeasor IES, because it's simply the other side of the same coin. So an order is placed. That requires a decision to be made by Genee World as the supplier. The fulfilment of the order is really the causative event in terms of causing the breach of exclusivity, because an order that's placed and Genee World says, well, sorry, we've got exclusivity, I'd love to be able to supply, but we can't.
But then there's no breach.
Which is why these questions are mixed. What Kawasaki seems to be urging at the beginning is, in order for there to be inducement properly so called, you actually first have to identify something independent by the alleged tortfeasor. And the mere placing of an order, which of course is mutual between the party placing the order and the party potentially supplying the order, is a question for the contract breaker. Is this order fulfilled or not? So the mere placing of the order hasn't in any way operated upon, corrupted, influenced, unlawfully influenced the mind of the contract breaker. It hasn't done that, whereas the editors of Clark and Linsell saying OBG very noticeably reduces the scope, and Kawasaki suggesting that there is something more, as the judge, exactly as the judge accepted, we submit is correct. Paragraph 48 is the other paragraph that I'd invite the court to look at, because it addresses directly the second of the two authorities upon which the appellant places significant reliance, namely Lictor-Anstalt. Which is of less assistance because it was a question of whether there should or shouldn't be summary judgment, but nevertheless the issue was in play on that summary question. Inconsistent dealings can be a form of inducement if, but only if, they meet the accessory liability and causative participation criteria articulated in OBG and Allen. Because what was in issue was a deliberate hive-down arrangement, that couldn't happen without Mere Steele's participation in a way which was necessary in order to enable the contract breaker to break the contract in the manner in which it intended to do.
Why is that reasoning not equally applicable here? The involvement of Genee World was necessary part of it, because otherwise there could be no breach of the exclusivity.
Well, Lictor-Anstalt is one step removed. It's about the contract breaker having a fixed motivation that there would be its intention to break the contract by a particular mechanism, and it needed a counterparty to be on board with that aspect of breach. Here, we're not on all fours. There's simply an order placed, and it's over to Genee World as to whether it intends to abide by its exclusivity contract with Northamber or not. The third defendant...
Clear from the authorities we've seen that it doesn't really matter which way round it is, whether it's who's asking who to contract. At the end of the day, the contract is the plainest example one can have of operating on somebody's mind, because there has to be a mutual agreement. And you can't have the mutual agreement without somebody either offering to contract with you or agreeing to accept your offer to contract. So whether it's IES offering to contract, which Genee accepts, or Genee offering to accept, which IES accepts, if they enter into a contract, Genee's mind has been altered. It's entering an agreement. And it's only doing that because IES is agreeing to contract with it.
Well, that is one way of looking at it, of course, that the very fact of offer and acceptance to make the binding contract requires inexorably participation by the offeror and the offeree. And so it must follow.
Is that all of these passages are not considering the very simple case.
Well, they're still of some assistance in terms of
Well, of course they are, but what I think
putting one's finger on the core element. At the moment, my argument is that OBG is recognised as a significant and policy shift reduction in scope of liability. Lord Hoffman at paragraph 36 has found favour as encapsulating what's required before somebody can independently found to be a tortfeasor. This court in Kawasaki is adopting that concept, saying that you have to step back and think about at large what's required for accessory liability, and what does causative participation mean.
Well, you're absolutely right about causative participation, but what do you say about Salvadori? Because one can see that this is another decision of this court, and a very recent one, which is approving through the medium of Lord Hodge and Go-Over on Resources, Salvadori. Of course, it was previously approved in Witness and United Artists. And why is Salvadori not support Popper's argument?
It does support the argument.
Right, so how do you get out of it?
Yes, if one goes to Clark and Linsell, the loose extract, so the 24th edition, paragraph 23-51, this takes us to my Lord Lewison's point about CBS and Amstrad, which is actually mentioned in the footnote. So, in the middle of that paragraph, the key question may be whether the contract party required a counterparty for an inconsistent transaction in order to break the contract. Since there is authority for the view that it is an inducement to facilitate, at least where some active step has been taken, footnote 238C Salvadori. However, the editors note that that runs counter to the normal rule, which is that a party is not liable if all he has done is to facilitate a tort. So you can't take this tort out of the general run of tortious liability, where the question of facilitation is mere facilitation enough to found tortious liability. The editors say probably not. Footnote 239, CBS and Amstrad and Credit Lyonnais against Export Credits, House of Lords, one appeal case is 486, which we actually don't have that decision available, but it goes back to CBS and Amstrad, where the argument was Amstrad had invented a twin deck tape machine. Inevitably, members of the public would use such a machine to put in a cassette on the left, a blank cassette on the right, make an unlawful copy of a copyrighted cassette on the left. Question was Amstrad arguably a joint tortfeasor with the public, the members of the public who would inevitably copy and breach copyright? The House of Lords said no, because there's absolutely no active element by Amstrad and no element of participation with members of the public who were engaging in unlawful conduct.
The choice of how to use the machine was up to the purchaser, the member of the public,
Yes.
and it was capable of being used in a perfectly lawful way.
Yes, yes.
And what would you say to the proposition that in circumstances with which we are concerned here, this goes beyond mere facilitation, because the breach of the exclusivity cannot take place without a counterparty. So it's not facilitation, it's a necessary element for the breach of contract to occur.
Yeah, well, I can see the distinction with CBS and Amstrad. You can't have there's either a breach of the exclusivity agreement or there isn't. You can't have a lawful departure from the exclusivity agreement. If there's a contract that's inconsistent with it, then you've got a breach of the exclusivity agreement. Of course, that distinction has to be recognised. This court is going to have to reconcile the general law, this tort, as against the general backdrop of tortious liability, and decide whether facilitation in this context is sufficient.
Well, it's a question of what you mean by facilitation.
Yeah, well, I'm favouring the concept that before you find independent liability on IES, you have to find something active, more active than simply placing an order, something that is actually capable of operating on the mind of the contract breaker. My Lord Justice Phillips favours the view.
If you take this at the most literal level, I can see that placing an order is not enough because the supplier might refuse to fulfil it.
Yes.
So it's not just placing the order which is an issue, it's placing the order, making the contract, receiving the goods, and paying for them. I mean, if one looks at this in a realistic sense, the dealing, the inconsistent transaction dealing, whatever it is not complete when the order is placed. So, taking the judge at the most literal, of course he's right to say that placing an order is not enough. But that's not in reality what the complaint is. The complaint is not, oh, UIES placed an order with Genee. The complaint is, you took delivery of and paid for goods which should have come from Claimant.
Yes, I mean, the judge, as we've seen, firstly stripped down what the apparent case was, which is this, we think, was pursuant to a concerted aim to undercut. We can't abide by that. The judge rejected that. We're not saying that he's wrong to have done so. So instead, we simply say, forget about the statement of case. The placing of an order is enough, and the judge was wrong to decide otherwise, saying that needed to be something more. But the judge rightly focused on, in what real sense can it be said that IES's placing of the order operated on the mind of Genee World? The judge thought that was a necessary element and thought that that was completely lacking. Insofar as the judge approached it that way, he was faithful to paragraph 36 of OBG and Allen, and indirectly, although the case was not addressed, it was faithful to the very fine distinction that's being drawn in Kawasaki, at least potentially, on one reading of it. Because certainly it's not said at paragraph 48, well, it doesn't matter. Nothing in Lictor, none of it mattered what the contract breaker's attitude was about how that contract would be breached by a deliberate hiving down scheme. And it didn't matter whether Mere Steel was on board with that or not. The court could have said, all that's completely academic anyway, because the fact that the order was placed was sufficient. But of course, the court did not say that. And at 48, that is regarded as, it appears, as a point of distinction.
So can I be clear? Is it your submission that Salvadori is no longer good law?
Well, we know that it's not addressed directly in OBG, and I think I'm correct.
To be sure, but we've just seen that it's indirectly approved in the Kawasaki and Kendall.
Yes, only insofar as it's through GRG against Mackay. It's not separately addressed.
To be sure.
Yes, on the list.
Although it was endorsed pre-OBG by Rickless. So, I repeat my question. Do you say that Salvadori is no longer good law?
Yes, you should follow footnote 239, not footnote 238.
And your basis for saying that Salvadori is no longer good law is what? It's been impliedly overruled by OBG?
it's impliedly overruled by Kawasaki in that
That's a bold submission.
Well,
How do you
when-
get that
when-
result?
when you look at these three paragraphs together, particularly paragraph 48, that point of distinction can't be expressed in the way in which it is, if in fact that's all completely academic and the mere fact of the contract is enough. That reasoning is redundant if that's the view. So
Well, I mean,
the
that-
addressing of a case which is potentially against the conclusion that's being urged.
How can it be impliedly overruled by Kawasaki when there's previous binding Court of Appeal authority endorsing Salvador? It could have been theoretically impliedly overruled by OBG. That's a theoretical possibility. But how can it be impliedly overruled by the Court of Appeal, particularly in circumstances where they appear to be endorsing it indirectly?
Well, I can't, only for the reason that I've advanced by reference to paragraph 48, that
The highest you can put it, I think, is that what the Court of Appeal in Kawasaki are endorsing in paragraph 42, and they quote Lord Walsh, is that inconsistent dealings, the tort can be committed where A has dealings with B, which he knows are inconsistent with the contract. Not will be, but can be. And then you go on to 48 and say that Lichter doesn't cast doubt on the proposition that inconsistent dealings can be a form of inducement if they meet, etc., etc.
yeah, well, what I take from
You still have to meet Lord Justice Arnold's point that Salvadori and the quotation from Mr. Justice Roxburgh was expressly approved by this court in Wriglers.
What I particularly take from paragraph 42 is the deciding factor. It is capable of amounting to inducement if, because it's capable of constituting a form of persuasion, encouragement, or assistance.
Yeah.
And we say, particularly for the reasons that the judge expressed and the manner in which the judge analysed it, that the mere placing of the order by IES, leaving it to Genee World as to what Genee World did or did not do in respect of fulfilling the order, didn't have really any active element. It was not a persuasion, it was not an encouragement, and it was not an assistance. It was something that met the but-for causation threshold, but that's all it met. And so that's not consistent with the general run of tort, footnote 239, that mere facilitation, stepping back, is insufficient to attract tortious liability.
So I think in answer to an earlier question from Lord Justice Arnold, you are saying that but for causation is not enough.
Yes.
And that is quite often the case in the law. In some cases, you need what's sometimes described as a proximate cause or a powerful cause, or whatever it is, or a causa causans rather than a causa sine qua non. And you say that's the causation test for inducing breach of contract, and merely to apply the but-for causation test brings in too wide a range of activities which have no real effect on the actions of the contract breaker.
Yeah.
Is that how you put it?
Yeah. And I use the phrase independent causation, i.e. something that the tortfeasor has done that's different to what the contract breaker was doing in any event. And then we're back to, well, is there any operation on the mind of the contract breaker? Those same sorts of concepts. They're all ways of identifying the same thing, which is the mere fact that it can't happen without the order being placed is insufficient. It's against the entire fundamental concept of tortious liability, that if you're taking a third party as an accessory, attracting independent accessory liability, then you must put your finger on independent tortious conduct by that entity.
Yeah.
can I ask it, in a situation where a third party knows about the exclusive contract and also intends that if it places an order with the contract, with the party under the restriction, that will lead to a breach of the exclusive obligation. It then places an order, goes through with the contract. What more do you say has to be done in order to give rise to active participation liability?
You still have to find something that operates on the mind of the contract breaker, because
What would that be? Give me an example of what would let's say that the IES says, please accept my order, which I send to you in order to induce and procure that you breach the exclusive contract that you have made. Would that be enough?
well, the lictor Anstand example seems to be identified in Kawasaki as a particularly useful example, which is that the contract breaker has a motivation that he or she then needs the alleged tortfeasor to go along with. Participation in the hive down scheme. Without that element of participation, it can't happen, which is different from simply the regular placing of an order. That fits better with the notion of causative participation, because and of course we're inevitably crossing over a bit to ground two, which is there a combination that could make out a conspiracy? But the reason why Northamber's case at trial was so similar in respect of inducement of breach and conspiracy, as in fact the judge noted, is because they were confronting what we say is the necessary element, that you've got to have that active participation by the tortfeasor. And simply placing an order and then in no other way influencing Genee World's decision as to whether it does or doesn't fulfill that order, and if so, on what terms, is self-evidently not something that's operated on the mind of Genee World, the mere placing of the order. The gap may be a small one, but we say the gap is still there nevertheless.
I'm really struggling with this concept. How can Genee World ever supply goods agreement unless somebody agrees to take them?
Well, of course that's true, but still, if the judge says Genee World is evidently of a mind to break the exclusivity agreement come what may, and indeed has already been doing so without any regard to IES, the additional placing of a mere order by IES is not something which would appear to be capable of operating on the mind of Genee World, unless there's something about the manner of placing that order which actually can be seen to operate on the mind.
But isn't the problem with that argument that it treats different breaches as being, as it were, a conglomerate rather than individual breaches of the exclusivity agreement? I mean, I think Mr. Coppell in the end accepted that placing of orders by IES couldn't cause Genee to supply other third parties, but the converse is equally true, isn't it? The fact that Genee had decided to supply other third parties doesn't mean that IES escapes liability for its own orders.
Well, unless on the overarching question of what's necessary to build up an independent case in tort, actionable tort against IES, unless you include the element inducing or procuring in the classic or the literal sense, which is that it doesn't found independent tortious liability unless there is that element of operation on the mind of the contract breaker, which the editors of Clark and Lynch will say is a better fit for the general run of tortious liability, which is why there's a preference for the CVS and Amstrad line of reasoning as opposed to Salvadori. in those two footnotes that are side by side. Fortified by Lictor and Anstalt, the review of it at paragraph 48 of Kawasaki, that point of distinction can't make any sense unless it's got some materiality. The materiality is that is in fact a case where you can identify something additional by the tortfeasor which makes a difference.
Yeah, well, I think we've put our points to you
Yes.
on that ground. And don't let me stop you if there's anything more you want to say about it.
Well, it's just to revisit paragraphs 218 and 219 in the
Yes.
judgment.
Yes.
Which I think then comes full circle with where I started, which is that the appellant's case is actually a subtle shift from the case that it put to the judge. Facilitation by enticement, it's got no case on enticement actually, unless you say, oh, well, the order itself is something that entices the contract breaker, which is the observation that's been put and may find favour in the end. But 218 and 219 seems to us to be a finding of fact that Genee World's mind was not operated upon. Through A, B, and C, and if they are a finding of fact that Genee World's mind was not operated upon, unless the appellant persuades the court that that doesn't matter, then those findings of fact do have a place. Unchallenged findings of fact, because then ground one would simply be facilitation, not facilitation by enticement, because it's common ground, there's no enticement.
Right.
Well, it must have changed their mind, because unless it changed their mind, they wouldn't have supplied the goods. They're not going to provide the goods for nothing, are they? They're only going to provide the goods to somebody who offers to pay for them.
Yes, there's no, I mean, for example, there's no evidence that, that there's no danger money changing hands. We know and you know that we're not supposed to do this. So what are we going to do to abide by the event that this gets challenged? There's no element of a combination.
There's far too much complexity into it. It's very simple. We know that the mental element is not in dispute here. We know everyone's got the requisite intent,
Yes.
knowledge and requisite
Of course,
intention.
of course.
We're only talking about whether or not this is sufficient from an actus reus point of view.
I agree.
And what we know is that, but for the purchase order or similar, these goods would not have been supplied. So I'm not sure why that isn't. I don't see why that isn't transparently affecting Genie's state of mind.
Well, we have, I hope.
Maybe going around over.
Well, we've certainly boiled it down, I hope, to the two footnotes in the latest edition of Clark and Linsell, 238 and 239, and it's whether in that respect facilitation is salvadory sufficient, or does that upset the general concept of what's needed for tortious liability on an independent basis or not. The court could easily say there could be an exception in this territory of economic tort, or it may say, well, that presents anomalies which are deleterious.
Yeah.
I would propose to move next to the question of justification, because it fits here rather than anywhere else. It's justification for the inducement.
And this is your respondent's notice?
Yes.
Where the judge was against.
Yes, the key paragraph of the judgment is paragraph 302, 303.
So
Well,
you,
this
have,
is-
you have to say the judge was wrong.
Yes.
Yeah.
And the first matter that I recognise is I have to explain why that's not the territory of a cross appeal and can practically be the territory of response notice, as to which the recent decision of brace yourself against NHS England, which I've put in the ring binder, assists me, I respectfully submit, because at paragraph 30 it's there explained that appeals are against orders. If the third defendant has won at trial, then it's clearly not appealing an order, and you can, under a response notice, challenge a finding of fact or an element of the judge's reasoning. Having addressed that procedural matter, really the start point for the argument of justification is paragraph 161 of the judgment. Which is the refusal of Northamber to supply D3. And D3's case from first to last was, in those circumstances, it had no option, if it wanted to protect its business, but to make the approach direct to Genee World.
But that's only dealing with the period to the end of February 2018. I appreciate that is, well, in fact, to be more specific, it's concentrating on the 15th of February to the end of February 2018. So it's a period of what, a couple of weeks or so.
Well, let me put that in proper context then, elsewhere in the judgment. Firstly, paragraph 30. In fairness, it's 29 where the issues are numbered and listed. Issues 5 and 6. What was the cause of Northamber not supplying IES in February? Was this factually incorrect? And 6, did Northamber supply IES with Genee World products after February 18? There are issues 5 and 6 within paragraph 29. And at paragraph 30, the judge explains that issues of 5 and 6 are important because the non-supply by Northamber to D3 is relevant to the defence of justification. We then move on to para 158. There is actually very detailed treatment by the judge of what led Northamber to cease supplies. And that is D3 being mixed up with D1 in respect of the relations with Lloyd's, the factor and Northamber contributing to that. If one looks at F at the top of page 163 of the bundle, it's important to note that orders were already in place. So IES had already made orders with Northamber. But that Mr. Hall, the credit manager, made a decision that those orders would not be fulfilled unless and until the position with Lloyd's was resolved. That finding by the judge, it is worth noting, accords with the third defendant's defence. If one keeps a finger in page 163.
About credit, because as the judge makes the point, Northamber was willing to supply goods to IES cash on delivery.
Yeah, that's true. Yeah, that's true. That's a part of the justification question. Is that sufficient? You couldn't have them on credit as you'd always enjoyed, but you could have had them on cash on delivery. That is relevant to the question of justification. But just while we're at F, that finding by the judge that Northamber made the decision to not supply, that does fit with how D3 had always set out its case on page 328 of this core bundle, letter N. Namely that, well, we know you're caught up in broader affairs that affect Lloyd's position vis-a-vis Northamber and Northamber's position vis-a-vis the First Defendant. But we've made the decision anyway. Then at J, back on page 163. Confirmation that the credit facility had gone. No credit was being given for the cross-applied 130 odd thousand, and so the balance standing as owing, at least as far as Northamber saw it, was 169 odd thousand. So it's 160. The judge finds that for that period from 6th to 15th February, the cause of IES not having its orders fulfilled was because Northamber had decided not to fulfill them, and that IES was either unable or unwilling to pay without further credit being extended. 161, for then the further period of 15 February to the end of February, IES was not supplied, and the cause of that non-supply was a failure of communication within Northamber. The judge finds, had Northamber realised that in fact IES's debt was only 31,000 and that was within normal credit terms, it wouldn't have had a basis for refusing to supply. Uh, 161B, IES was again unwilling or unable to pay Northamber without that credit facility, historic credit facility remaining in place, and C, IES was not willing, as a way to short circuit that, to allow Northamber to approach IES's own customers direct. Then I think we can go to paragraph 219.
Can I just pause a moment? Leave aside all this credit history. Let us suppose that there is a contract between A and B under which B has the exclusive right to distribute goods in a certain category in the UK. And C would like to acquire some of those goods. So C goes to B, says, will you sell me some of these goods? And B says no. Whatever it is. I've had dealings with you in the past, or a new startup company, or whatever the reason is. You say it's justification for C to go to A and say, sell the goods to me, even though you've got this exclusive arrangement with B, and I know about it, and I know perfectly well that if you do sell to me, that will be a breach of the exclusivity agreement, but I've got business interests of my own. Is that good enough?
No, not necessarily.
What makes this different?
Well, I think the guidance that we have boils it down to this, which is that the party pleading justification has to have an equal or superior right. And the question is, what on the facts could be said to be capable of being an equal or superior right? The third defendant had always said it could scarcely not fulfil its own orders. These are significant pieces of equipment for schools and other educational institutions where they buy whatever quantity of electronic whiteboards and all the other audio-visual display systems. These are not trifling orders. Non-fulfilment is likely to destroy or seriously damage the relationship with that particular customer. There's the further likelihood within the territory of the market that other customers would learn of issues of non-supply, which can very rapidly cause reputational loss, and so on and so forth. And Northamber's solution, in inverted commas, for this, well, just let us go to your customers direct, was not in any way commercially palatable because of the loss, or at least the potential loss of the valuable customer connection and customer relationship to Northamber, with suddenly IES being cut out of the picture.
So the right that you rely on as being the equal or superior right is the right of IES to carry on.
Well, to protect the viability of its own business, to protect Mrs. Corr's livelihood through D3. The judge seems to have concluded, well, she's just wanting to keep to profit-making contracts upon which she'll turn a profit through her usual margin, which is an odd way of looking at it, to take that element, to divorce it from the reality of the inevitable necessity of having to fulfil orders to protect one's customer base. And we say there's enough in what was available to the judge to make out a good case of justification. At 219, which is where I was about to go next, in the judgment.
Just before you do that, just to understand, you showed us the paragraphs where the judge was looking at what happened as a matter of fact between Northamber and IES. What is your case as to what that amounts to? Was it a breach by Northamber?
It was an unjustifiable dragging in of IES into a collateral issue. Northamber's own difficulties with Lloyd's were the unjustifiable provocation of the manner in which it treated D3. It's not a breach per se of any subsisting relations between Northamber and D3, but it doesn't need to be in order to be capable of amounting to a defence of justification.
Well, you're saying it has to be an equal or superior right. It doesn't sound as though, from what you're saying, that T3 had any rights.
Well,
compared to the right of Northamber, which had a contractual right.
I wouldn't accept that the phrase of equal or superior right is restricted to express rights that you can identify, and certainly not express contractual rights. You just take an overall view as to the quality of the justification defence, but we'll come to that more directly in a moment. At paragraph 289.
289.
Yes.
Yep.
Page 199 of the core bundle. That's how the justification defence was summarised by counsel for IES at the trial, which is that given that Northamber had made a conscious decision to refuse to supply, even after the whole of the overdue debt was discharged, IES were left with no choice, if it was to fulfil its own orders, other than to approach Genee World directly.
Yeah, can you just help me on this? Because it may not matter for your purposes, but something I found hard to understand about this judgment is he uses this abbreviation, LBCF, which is introduced, so far as I can see it, in paragraph 9 of the judgment. He never explains what LBCF stands for, or who that party is and what their role or at least if he does, haven't found it. So
Yes.
can you help me? First of all, what does LBCF stand for? And secondly, who were they and what was their role?
I think it's Lloyds Bank Commercial Factoring. And I think at paragraph 9 of the judgment, the judge explains that actually both Genee and IES had an invoice discounting arrangement with Lloyds Bank to receive an advance of 85% of the value of their invoices and the balance of 15% less the charges thereafter.
Right, but if it's correct, as was being suggested, that Lloyds Bank Commercial Factoring was starving IES of cash, why is that Northamber's fault?
Because of the reasons summarised at paragraph 158.
Right,
Well,
let me put the question
Sorry.
a different way, which perhaps may be more helpful. Did the judge make a finding that IES was starved of cash by LBCF because of some fault on the part of Northamber, and if so, where?
Well, if one looks, I mean, we're in the right section here, 158 to 161. So if one looks at, firstly, letter I within 158, towards the top of page 163. Northamber was trying to fend off LBCF because LBCF took over the book and was therefore able to chase the Northamber directly. And Northamber wanted to apply a set-off. Lloyds would not agree, threatened a winding up petition against Northamber.
So they're both victims of LBCF?
No, Northamber had no right to insist on a set-off with Lloyds. But nevertheless, it suited Northamber to put D1 and D3 together in terms of its efforts to fend off Lloyds. It made a conscious election to do that. D3 was being aligned with D1, whether D3 liked it or not. That was to the detriment of D3. Northamber didn't relent. See paragraph 160B, final sentence. Mr. Hall for Northamber refused to release any goods to D3 until the position with Lloyds was resolved, which, in my judgment, meant until Lloyds agreed to the set-off, which Northamber was never in a position to mandate anyway.
But so isn't your problem with this defence that Northamber were willing to supply goods if IES paid for them in cash? Judge makes that finding at 162C. So this wasn't a question of Northamber actually refusing to supply IES, it was a refusal to give them credit.
Yes, but I mean, if D3 had always had credit
Well,
and had relied on the credit, to suddenly say,
well, where is the evidence that that is so?
well,
Or the finding rather that that is so. But anyway, that's point one. Point two is that Mrs. Core was not prepared to Northamber supplying IES's customers direct. So the orders that had been placed could have been fulfilled, not by IES, it's true, but by Northamber. And that may or may not have been a temporary thing until the position with LBCF was sorted out and or IES was able to pay for goods cash on delivery. So how does that amount to permission to commit a tort, or what would otherwise be?
Well, I agree that that's not addressed directly. So in the way in which the court asked my learned friend what would happen if there was something in these grounds, I say the same in respect of justification. One would have to go back on a narrow remittal to test. Was it reasonable, given the history and the known history, or insofar as it wasn't properly explored at trial, it should be properly explored at trial?
Sorry, the judge addressed all of these questions, as you pointed out to us earlier, at 302. It's not that he ignored them.
Well, he doesn't.
He says, I mean, his first point in 301 is that he's not satisfied that IES has proved it would have breached contracts with its customers if Genee had not supplied it with Genee World products after 23rd of February. And then he says, in any event, it appears Northamber was willing to supply without credit or to supply customers direct on credit, and that was refused. And he also makes the point that IES never went back and challenged the assertion that £169,000 was owing. So he gives a whole series of reasons for not accepting the case on justification.
But
You may say that he's wrong,
yes.
but you can't say he's ignored the points.
No. There are two different things here. I can advance the respondent's notice by, on the one hand, saying the judge is wrong in the conclusions that are expressed, and I can also acknowledge that on the two propositions that have been just put to me, why would cash not be good enough? Could D3 have lived with cash? It depends on the history of credit and the known reliance on credit. That may need to be explored further. And
but the trial is the time for exploring these points. As I've said elsewhere, it's not the dress rehearsal. If you've got a point to be made about the inability to fulfil orders because the switch from credit to cash was devastating, and the time to advance that and to reduce evidence is at trial.
yeah, well, of course that's true. But if I advance an appeal in support of the respondent's notice that the conclusions of the judge on justification are arguably wrong.
No,
that
arguably wrong is not good enough.
Well, are wrong, sorry. If they are wrong, the question then is what's the remedy on what should happen?
But you can't say that they are wrong because there was other evidence which you might have brought forward that didn't.
Oh yes, I'm not, in fairness, because when one gets to 302 and 303, but just on the way there, can we pick up paragraph 294?
Yeah.
Which is an answer to my Lord Arnold's questioning about LBCF. So the judge concludes that in the ordinary way, LBCF applied reserves to the invoice discounting ledger wherever it considered there was a risk that debts which had been assigned to it wouldn't be collected. Application of those reserves reduced available funds. But on the facts of this case, LBCF applied reserves for, amongst other things, the difference between the debts owed by Northamber and the credit insurance applied for those debts, provided for those debts. In respect of Northamber, that reserve would reduce over time as Northamber paid down the debt it owed to Genee. When it appeared that Northamber intended to apply a set-off of the overdue debt owed to it by IES against the debt it owed to Genee, LBF applied a reserve equivalent to the set-off. The amount of that reserve increased over time up to the 15th of February. D, the combination of A to C meant that the ledgers that LBCF operated on a combined basis showed very little, if any, funding, i.e. it's the result of Northamber illegitimately mandating that there be the set-off. That caused the problem with Lloyds, that caused the knock-on problem from Lloyds to Genee and IES. That led to Mr. Hall saying to Mandy Kaur, I've made the decision, you're not going to be receiving any supplies from us until the Lloyds issue has been resolved. That was the judge's finding. Then at
No, that wasn't the judge's finding. The judge's finding was that you're not going to receive supplies from us on credit.
Sorry, on credit, yes. That was para 162. The disposal of the justification defence is at paragraphs 302 and 303.
Yes.
The judge concluded that IES's desire to avoid breaching its own contracts with customers couldn't be a lawful justification. But there is no reasoning given as to why it could.
I'm sorry, the judge explicitly said he wasn't satisfied the IES would be breaching any contracts with its customers. And therefore, all that was left with was a loss of profit claim.
Well, he didn't resolve whether it was an inability or an unwillingness to take the goods on cash as opposed to credit. He didn't examine whether in fact that was even feasible. He repeatedly says unable or unwilling, one or the other, and I can't decide which. Well, until he's decided which, what if it's inability? What if it is inability as opposed to unwillingness? If it were to be inability and IES couldn't keep its contracts with its own customers unless it continued to enjoy the credit which it historically enjoyed by Northamber, that could be very relevant to a defence of justification, because the third defendant would then say, I can't allow my contracts to collapse because that will have severe knock-on consequences for the business. But I can't do anything about it other than capitulate to Northamber's demands, which are 1, pay cash, or 2, let us cut you out of the equation and we'll sell to your customers direct.
My lord's point, I think, which was that in paragraph 302, the judge found that he was not satisfied merely because IES has produced some orders dated around March 18, that IES has proved it would have breached contracts with its customers. Genee had not supplied it.
Now that's a finding of fact. And the other point that you need to deal with, or at least have an answer to, is that Northamber were not saying they were going to cut IES out, because the judge says that Northamber was willing to supply customers direct on credit with the profit accruing to IES. So IES were going to get the profit, customers were going to get credit terms, but the supply would be by Northamber. And that again is a finding of fact.
Well, yes, if and to the extent that IES could afford it, the judge doesn't answer that question. He says it's either unable
afford what?
to afford to buy the stock on cash as opposed to credit. He says they're either unable.
No. Come on. You need to read this sentence. It appears Northamber was willing to supply Genee World products to IES without credit. So that's alternative number 1.
Yes.
So that's cash. Or, this is alternative number 2, to supply customers direct, so that's the Northamber supplying the ultimate user,
Yes.
on credit, so no need for IES to find any cash, with the profit accruing to IES, so IES not being cut out. But Mrs. Kaur refused that.
Not cut out in the sense of still receiving the profit,
Yes.
but opening up its customer base
Yes.
to Northamber,
Yes.
which Mrs. Kaur in her trial witness statement has been
Well, that's
very clear.
that with respect is a different point from saying we would have breached existing contracts with customers. That's saying we wanted to preserve our goodwill, if you like.
Yes, no, of course it is different. The judge the judge never properly grapples with, is it viable, is it commercially palatable that IES suddenly now switches from credit terms to cash terms. He says they may have been unable to deal with that, or they may have been unwilling, and we don't know which one it is. If it were a genuine inability, then the justification defence can't be killed off in 302 on the basis that, well, what are you complaining about? Because you could have had the stock anyway, but you just have it without credit. He hasn't answered that, or he hasn't engaged with it properly. The second...
Well, was there evidence to say we couldn't have done this? We couldn't have done this on cash terms.
Well, I was hoping for the indulgence of being able to show the court Mrs. Corr's trial witness statement in a moment. It's one of the things that's in the unagreed bundle.
Well, what's the answer?
Which I've marked
What's
up.
the answer to the question?
I'll have a look ahead. I don't know for 100% without checking.
But also one would need to know if there was any cross-examination.
Well, she certainly says that she heavily relied upon the invoice discounting, which of course had been fundamentally compromised by Northamber's conduct, so that's partly helpful.
How does that square with the fact that IES never challenged the mistake on the part of Northamber?
Forgive me, my lord, I was reading, I just missed that question.
I said, how does that evidence square with the judge's finding that IES never challenged Northamber's mistake about the amount that was owed?
Well, the judge doesn't appear to have regarded that as having any material impact, because
This is one of the points he relies on in 302.
when
It says if that had been pointed out, then North Star might have continued to give credit to IES. That's what he says in the last sentence of 302.
Sorry, I thought I was being taken back to the first review where he explains how Mr. Hall made the decision.
I think Lord Justice Arnold was putting to you the last sentence of 302.
No, I realise. Yeah, no, I realise that now. It comes back in, yes, as part of the rejection of the justification defence, which I'm now seeking to build up. So, firstly, there is an insufficient or unreliable conclusion as to whether D3 could actually, as a matter of reality, have coped with the two alternatives that were being put forward by Northamber. The idea of cash, I say, was answered by the evidence because Mrs. Corr had explained in her witness statement that IES's last bit of savings had already been used to cover staff salaries. Then, in respect of opening up her customer base for direct relations with Northamber, regardless of the profit element being protected for the benefit of IES, she said that she couldn't contemplate that because of the risk of future damage to the business. And the judge does not properly address that. He disposes of justification in an extremely brief manner, simply by saying, trying to avoid breaking onward contracts with IES's own customers is not good enough, but it could be good enough if there was an inability, a genuine inability to do anything else to protect those customer connections, and the judge has not answered that prior question. And then 303 is more of a question of principle about whether it's even capable of falling under justification, and the judge seems to conclude that trying to protect your own economic interest just simply can't, as a concept, amount to justification, and we say that that's wrong.
Why not? Because if simply protecting your own economic interests is enough, this tort would never be committed. Because people do it precisely because it's in their own economic interests. You've got to have something more for a lawful justification. Wasn't you?
That's why Mr. Guy wanted Miss Wagner to sing for him.
I think the answer to that particular question is in Clark and Linsell at 2353, which is the loose extract that was slotted into the blue ring binder.
2353.
Yes.
It's in global. The answer is in global, cited at the top of page 204.
Maybe we'll come to that next.
No, I don't think it's. I think it must be a different.
Yeah, I think it's the final sentence of 2353.
Defence justification open in order to protect.
Yeah, well, that supports your submission about equal or superior right.
Yeah, but more.
But an equal or superior right is different from own economic advantage, isn't it?
Well, the final part of that sentence, even if the method of doing so is of commercial advantage. So the mere fact that D3, as part and parcel of just protecting its customer base, keeps the contracts, therefore keeps the profit margin that it would make on the contracts in the usual way, that element of commercial advantage doesn't mean that you can't have a defensive justification. But of course, the judge at 302 and 303 is contrary to that idea.
Yeah.
He seems to conclude that if you're trying to maintain contracts which will generate some economic benefit, then almost axiomatically that can't amount to justification. We say the guidance is the opposite of that, that there's nothing wrong with the defendant saying, I'm desperate to protect my customer base, so as to not ruin a customer connection, so as to not cause knock-on reputational loss, so as to not suffer any element of loss of profit which would dent the business's viability. There's an open question about whether I can do it otherwise than on credit, and there's an open question about whether it's reasonable to expect that Northamber can go to my customers directly.
Yeah. All right.
Could I bring paragraph 309B to my Lord's attention in the judgment, page 206 of the core bundle?
Yes.
As part of the rejection of the lawful means conspiracy, there being no predominant intention to injure Northamber, the judge does appear to have accepted the proposition from Mrs. Core that credit was needed.
Yeah.
So she had to go to Genee World because she needed the stock. She needed credit in order to get the stock. Therefore, it cannot follow that there can be any predominant intention to injure Northamber. So that's highly material, but the judge does not connect the two to the manner in which the judge rejected the justification defence.
Yes.
Within Mrs. Core's witness statement for trial, she had said, for reference paragraph 13, that she employed around 25 members of staff. Para 14, being a small business, she relied very heavily on the support of invoice factoring companies. Paragraph 44, as at the end of January 18, so immediately prior to the events which caused the problem, IES's last bit of savings had already been used to pay staff salaries. 49, as far as IES was concerned, the orders that had been placed with Northamber were being prepared and would be fulfilled, ready to deliver and install with the end users on the date specified. IES was not forewarned of any issues until the events that we've seen the judge deals with. Normal protocol therefore followed. Customers were advised of their delivery dates and so on. So this is building, and this is, as I understand it, how she expressed herself. This was building a particular head of steam which led to a very acute situation when Mr. Hall made the decision that he did, which is to drag D3 into D1's problems. Paragraph 64, I felt very confused and concerned after the call with Mr. Hall, having been assured that a solution was being worked upon.
Well, Mr. Budworth, and we're not here to try the case on the facts.
Of course, and with full respect, that is true, but it's an elaboration of why the rejection of the justification defence is not a safe rejection.
Right.
And it's to contextualise it. If I can be indulged with one more, paragraph 72, following Northamber's refusal to supply stock, IES had no other option other than to source stock from Genee World, otherwise it wouldn't have been able to fulfil its customer orders. So the material was amply there, and the manner of the judge's rejection, particularly if that finding at 309B is sound, which obviously we say it is, that she needed credit. The reasons for rejecting justification were just simply not adequate.
Yeah, right.
As to ground 2, conspiracy, we've travelled a lot of this ground already. If one goes back to paras 218 and 219 in the judgment, on the debate that we've had about what causative participation means for the question of inducement, what the judge has plainly found, we say, or he's plainly had the opportunity to find it one way or the other, but he certainly hasn't found positively for the appellant. There was no relevant combination.
Yeah.
Can I just ask you on that, because you've got a respondent's notice on this issue. It's your paragraph 3 of your respondent's notice saying no combination. Why would you need a respondent's notice if there was no finding of a combination?
Let me just remind myself exactly how that is phrased. Tab 9. Well, to spell out in express terms that which we say is already implied or implicit.
Yeah. Anyway, you made the point, there's no finding of combination. You made it in your respondent's notice in July last year, and you made it again in your skeleton argument, the date of which I haven't got to hand immediately.
Also July last year.
July last year. So that point's been on the table for 9 months or so.
Well, all I add is this. So 218 and 219, to my mind, confirm that the judge has found that the third defendant was looking out for itself. Genee World was doing what Genee World was doing in any event. There had been breaches of the exclusivity agreement well before IES came along and said Northamber won't supply me from you. Paragraph 302, the motivating factor for the third defendant was to avoid a breach of its contracts. Whether that was or wasn't capable of amounting to justification is a different question, but that was the third defendant's motivation. There therefore is no evidence of combination, and there's no finding of combination at 308. A.
Yeah.
Northamber has not asserted that IES somehow acted in concert with Mr. Singh in connection with inducing the breach of the exclusivity agreement. So that is extremely close to a finding of no relevant combination, if in fact it is not the finding of no combination.
beg your pardon, where were you reading from?
308A, second and third lines.
It may not matter, but do you defend 308B? The unlawful means must be the same unlawful act.
No. No. The critical criterion is combination, and then combination which has involved the use of unlawful means by one or more of the co-conspirators. And of course, there will be cases where there is a multiplicity of unlawful means, and there doesn't need to be a combination
No.
about what those unlawful means are.
Somebody steals the money and somebody else launders it.
Yes. The judge has been led astray, it appears, by D2's counsel's submission on that, or the submission has not been properly understood. 308B is not something that we say materially matters.
Not all the conspirators need perform an unlawful act at all.
Absolutely, yes. 309, which of course is why lawful means conspiracy wouldn't work, because there's no predominant intention to injure. But that does also seem to confirm at one and the same time that there's no combination. The reason for saying that is because Genee World, Mr. Singh was trying to make Genee World survive, whereas IES wanted to maintain its onward contracts and it needed credit in order to do so. So independent motivation, no combination, no relevant combination for conspiracy.
Well, your motive for entering into an agreement doesn't necessarily mean there isn't an agreement. This was a contract made between IES, the director, is the wife of the director of the company they're buying from, thereby putting the first defendant in breach of contract. It doesn't take very much to infer combination from those overt acts, does it? If the judge had turned his mind to that. The difficulty is the judge didn't turn his mind to it at all. He expressly disclaimed doing so. If you're going to get into the question about whether there was,
yes, it's whether the contract itself represents the combination.
well, no,
There wasn't a contract between Mr. Singh and IES.
No, whether the Genee World and the IES contract represents the combination, and then through the attribution of knowledge from D1 to D2, is that a sufficient combination between D2 and D3? The contract itself isn't a combination for the purposes of founding a good conspiracy claim.
but you infer a combination, and it may be a nod and a wink, as well as it could be a lengthy document setting out all the terms, but conspiracies are inferred from the overt acts. You don't.
Oh yes,
and the
because
fact that somebody has a motive, a motive for entering the conspiracy doesn't mean it's the conspiracy.
no. What I was saying is that there's no finding of combination. There is no basis for.
That's the be all and end all.
Well, I was going on to say.
He didn't even consider the question.
Well, we think he did if one takes the value of the cost judgment in terms of the ingredients as to conspiracy. We were very alive to the question of combination. We say there's no finding of combination, either in 308 and or in 309. But I was going on to say there's no basis for a finding of combination either. The mere contract itself can't represent the combination.
I think it
And-
would be difficult for you to get onto that ground, Mr. Budworth. You're better safer sticking where you are.
Let me just bed it in then with one reference to authority. In the authorities bundle at page 389.
Tab?
I'm
389.
I'm afraid mine isn't.
There, right, yeah, 389.
One.
389.
It's a seminal case on conspiracy in any event, Q8, para 111.
Yeah.
I'm really sorry, so I have to go back into the electronic, so can you give me the reference again? Sorry.
It will open at page 437 of the first of the two authorities bundles, and it's Q8 against Al-Badr number 3, paragraph 111.
Yes.
It was only to introduce this element, it's combination with a common intention, and what I'm submitting is that at 309, the judge has found that they come at this from completely different perspectives and are motivated by completely different reasons. So they can't have had a common intention to make the relevant combination either. Because there has to be a deliberate combination, although that can be tacit. But there has to be a deliberate combination for the purposes of founding an actionable conspiracy. And I was submitting that the reasoning at paragraph 309.
I'm a bit struggling with this because I take your point, no finding combination, okay. You're now addressing us on the basis of, nor was there any basis for a finding combination. And what you're relying upon, as my Lord Justice Phillips put to you, is findings about motivation. But what's motivation got to do with it? Because it's sufficient to deliberately combine, albeit tacitly, to achieve a common end. And why did they not do so? The common end here was that goods will be supplied from D1 to D3 in breach of the claimant's exclusivity. Why did they not deliberately combine to achieve that? They might have had different motivations, but why is that material?
Well, I was making an attempt to apply para 111 of Q8 to what the judge has said at paragraph 309, and it may be that it's an attempt to go too far, but where the essence is expressed as a combination which is deliberate in the sense of being motivated by a common intention, so it's a combination in that respect. The judge at 309 seems to conclude that the two relevant parties just have fundamentally independent.
Well, they had different reasons
Aims
for
and
entering into the combination if there was one.
Perhaps. Yes, perhaps. 309 seems to be so stark in terms of making a point of the fact that their aims and aspirations are fundamentally different and independent.
Yeah.
That the judge is effectively saying, I read the judge as saying, there
You're
can't
on
be the
safer-
relevant
You're on safer
combination.
ground with paragraph 307.
Forgive me, Lord.
You're on safer ground with paragraph 307.
Yes.
Before leaving this, what do you say about Mr. Coppell's application to amend his notice of appeal? Do you resist that?
I mean, if you want till tomorrow morning to deal with it, then we've said that we'll give you that time, you can have it.
Well, we do resist it, so we might as well explain that it is
If you're in a
resisted now.
position, if you're in a position to deal with it, do.
Yes. In fact, I had just been about to make one final reference, which is if one looks at D3's defence, page 331 in the core bundle.
Three, 3-1.
Yes, please, my lord.
Yeah.
Not only was the respondent's notice and the third defendant skeleton argument sufficient to cause the appellant to react if it had in mind to advance its case under conspiracy ground 2 in the way in which it now proposes. But of course, the task facing the claimant, we say we try to set out fairly and squarely in terms of the defence.
Yeah, it starts at the bottom of page 330, I think,
Yes,
where you say the claimant hasn't properly stated any positive case on, and then
A,
you
B,
say-
C, and D.
Yeah, all right.
So
you've got that.
proposed ground 7, in the manner in which it has emerged, I mean, it's only emerged because the court has identified the necessity of it being there if this argument can even be received. But neither my learned friend or I will have had an opportunity to speak to trial counsel about any of these aspects, which is a significant disadvantage and a prejudicial effect of this sort of thing happening. It seems, and doubtless we can make this authority available tomorrow, but the matter is addressed by decision of the Court of Appeal in the case of Hickey against Secretary of State for Work and Pensions. I don't at the moment know if it's reported, but the neutral citation is 2018 EWCA Civ 851. Which says as material as follows. It's important that this court, the Court of Appeal, like all other courts, is not a slave to form, but the CPR set out procedural requirements and they're not mere aspirations, they do so for good reason. The time of the parties and the court will be wasted if issues are not identified clearly and succinctly in the grounds of appeal, supported by relevant circumstances giving rise to the appeal, and the appellant's arguments set out in a skeleton argument. Without such proper focus, it's impossible for the appeal courts to deal with their prodigious workloads efficiently and effectively. Then a further statement of principle that the appeal court's jurisdiction is obviously constrained by the grounds of appeal and of the permission that has been granted, so that any departure will require an amendment.
That's why Mr. Coppell needs to amend.
Indeed.
Needs permission, which really go together. And plainly, it's very late.
Yes.
But nevertheless, the question remains whether it should be allowed.
Well, that's the conclusion in this authority which I was coming to, which is that can't detract from the requirement that an appellant who has obtained permission and wishes to add to or otherwise amend must make a formal application as soon as he reasonably can. The observations that the court has made to my learned friend are to the effect that this is an application that's made far too late and self-evidently can't be one that's been made as soon as it reasonably could be. Therefore, its consequences for the appeal are too damaging for it to be allowed, and the consequences for the respondents to the appeal are too prejudicial.
It seems to me that the initial problem with ground 7 as drafted is that all it does is challenge the judge's failure to deal with the issue. And it seems to me, on the basis of what he decided, he was entitled to say, I'm not going to deal with it. What it doesn't do is say that he should have found issue 8A in favour of the claimant.
Well, no, because that would immediately require looking at what ingredients Northamber were able to advance and give to the judge in terms of a conclusion that all the elements of a conspiracy were there.
Ground 7 gets them nowhere.
Well, I don't fail to take the opportunity to endorse that view, but my objection was a procedural one for the reason that I've advanced.
All right, we've got that.
ground 4, as explained,
Well, it's
I-
no longer suggested that your client is liable for orders not placed by it.
yes. And I don't think there's anything now being maintained in respect of the percentage. Is it 5% or 25%?
No, that was not pursued.
For comfort on that and fortification, internally inconsistently at page 122 of the core bundle, whilst on the face of it holding open ground 4,
Yeah, they say it was.
the appellant had,
He was a limited late. Yeah.
yes, but it's gone, and rightly gone,
Right.
which leaves ground 5. Which is a cost appeal.
If we are against you on ground 1, then ground 5, I mean, the cost order against your client have to be revisited.
Yes.
But-
I wondered whether my learned friend would take the opportunity to park it and see where we get to on the other grounds, but I can respond to the argument if.
Before we go on to ground 5, do you wish to say anything on ground 4 with the point that is pursued, which is interpretation of the exclusivity agreement?
No, I don't.
So, sorry, can I just be clear what your position is? I take it you're not conceding ground 4, you simply say the judge was right for the reasons he gave, is that it?
Yes, but unless I'm missing something fairly fundamental, it's not a ground
Oh, it doesn't affect your
which
client?
affects D3.
No, you're quite right. Thank you.
it's-
Yes,
it's
I should have picked that up, of
So
course.
why
Well,
does,
I
why
was
does it
nervous
affect
then.
your client? I don't
Well,
understand that.
it's simply the Vietnam supplies, as I understand it,
Yeah.
and
This is
You're being accused of conspiracy.
well, that,
You'd be liable
yes,
for-
I'm
you'd be
not
liable-
well.
You're liable for everything.
I'm not. Yes, I'm not being accused of inducing a breach in respect of those supplies.
You're being accused of being a party to an unlawful means of conspiracy.
Yes, I'm just checking.
You'd be liable for everything that the first defendant and second defendant are liable.
Yes, unless that conspiracy.
Missy, at the moment, there is no finding of a conspiracy against you. That's being appealed.
That is because, rightly or wrongly, I've interpreted ground 2 as being as relating to the same territory as ground 1, but I just need to check the appellant's skeleton argument. Yes, in the appellant skeleton argument, page 44 of the core bundle. As I interpret it, the conspiracy relates to the orders between D3 and D1. So it's effectively the same territory as ground 1. So placing the orders itself is sufficient inducement, and the placing of the orders itself may be sufficient combination in respect of those orders, the D3 and the D1 orders.
Well, I think in paragraph 31, it's shows the actions of both D3 and D2.
It's the very final line on page 44, pursuant to which conspiracy D3 made offers to D1, acceptance of which would necessarily breach the exclusivity agreement.
And D2, as director of D1, induced D1 to breach the exclusivity agreement. And that resulted in foreseeable loss and harm.
In respect of those offers, the same offers, the D3 and the D1 transactions.
Well,
Well, now, Mr. Budworth, we've reached 4:15.
Yes.
We do need to speed up,
Indeed.
so we're going to stop there,
Yes.
and we need to finish this by midday tomorrow, lunchtime tomorrow.
Yes.
And you need to give time for Mr. Ingham to make his submissions and for Mr. Coppell to reply. And we spent an awful long time on contextualising and doing all sorts of other things, so perhaps you would be good enough to think overnight about whether and to what extent you can shorten your submissions on ground 5.
Yes, I just have ground 5 left.
Yeah.
Well, subject to the court's commitments, I could finish that in 15 minutes in any event. If
No,
that
we'll have
says-
15 minutes tomorrow.
Yes.
10:30 tomorrow.